can I first inform you that before you are the 4 re-elected office bearers. My name is Stephen Thiru. I'm the President of the Malaysian Bar. On my right is George Verghese, Vice President of the Malaysian Bar. On my left, Karen Chia, Treasurer of the Secretary of the Malaysian Bar. And my extreme right, Farid Ghaffur, Treasurer of the Malaysian Bar. We had our AGM today, the 70th AGM of the Malaysian Bar. Attendance at the AGM was 1,110. 1,110. We had 5 motions before the House. All 5 motions were passed. The first motion was the motion by the Bar Council on continuing professional development, CPD scheme. The second motion was a motion by members, 3 members, concerning the Attorney General. Third motion was a motion on the Solicitor's Remuneration Order, SRO. The fourth motion was a motion by also a member of the Bar. Sorry, third motion was a Bar Council motion. The second motion was a motion by a member of the Bar on the National Security Council bill. And the last motion was a motion on internet censorship by a member of the Malaysian Bar. All 5 motions were carried. All right. Questions? If you have any questions?
So now that the Bar has passed the motion to call for the recognition of the AG, what can the Bar actually do after the motion has been passed? Can the Bar actually remove the AG from the position?
No, well, no. That's a motion of the Malaysian Bar now. But the Bar is proceeding with the action, the judicial review action, which is very separate from the resolution passed by the members. Separate in this sense. The action brought in court is against the office of the Attorney General, and the decision made by the Attorney General in the matter, the decisions that were in the press on the 26th of January 2016. All right, we know what the decisions are. All right, that's the action. All right, so that will carry on. So we'll proceed with that. Yeah.
So, in terms of people, I guess want to understand what is the significance of the Bar passing this resolution in terms of the Attorney General, and also there's some confusion here. Does the Bar Council have any bearing on the Attorney General's position? Is he a member of the Bar or is he removed?
No.
And could you just explain that for the public to understand?
Yes. No, he's not a member of the Bar Council. He's not a member of the Malaysian Bar anymore. He was a member of the Malaysian Bar and was a member of the Bar Council. What the Bar has decided today is that it has resolved that he should resign, and that resolution is a resolution of the Malaysian Bar, right? So that's it, and how it impacts him? Well, it's a call. It's a call for resignation, like any other call for the resignation. But this is a call that is made by the Malaysian Bar.
And would you say, in terms of the impact, what would you hope? Do you hope that he would recognize this call, or that because this is coming from a body of lawyers and he is also of the legal profession? So do you think that carries? Would you hope that carries some weight in some way?
It should. It should. If it's coming from the Malaysian Bar, which is the sole body that represents the practicing lawyers in Peninsular Malaysia, in West Malaysia, then certainly it would have a bearing.
The motion was supposed to be how many votes?
I can't get into to the votes, but it was passed by a majority vote.
So of the 3 motions regarding the AGC, the NSC bill and the censorship of the internet, would you say they're political in nature?
No, I think none of the motions are political in nature. If you look at the motion on the Attorney General, the concern expressed by members of the Bar is actually a concern about the rule of law and administration of justice in this country. So it's nothing to do with any political position or political situation. If you look at the motions that were passed in respect of the NSC bill and media censorship, again, those are all issues of rule of law as to whether or not the rule of law has been infringed. And we have 2 more motions which are actually practice issues. They are purely professional practice issues. The motion on the Continuing Professional Development Scheme, CPD, is a motion where we wish to empower our lawyers in terms of the supporting their learning, bettering them in their learning. So that's an everyday bread and butter issue for our lawyers, that we want good lawyers and well-equipped lawyers in terms of knowledge. Then the motion that we had on the SRO is again a motion, because SRO is about non-contentious business, is to enable members of the public as well as lawyers to benefit from a scheme, a scale fee scheme that we have at the moment in terms of price, what they can agree, all right, and so that it is not as difficult as it was in the past, where there was not possible to give discounts. We have actually today decided that one of the things we have decided is that a lawyer who's engaged in particular transactions can give discounts up to 25%. All right, so that's actually benefit for the lawyer because can take on the work and yet give a discount up to 25%. Benefit for members of the public because they will be able to get a discount. Previously they couldn't, no discount at all. So it's a balance. All right, we had rule of law motions and we also had practice, professional practice motions before the House today.
And being rule of law issues, it's under the purview of the bar. What say you about lawyers who are opposed to this, saying that the bar is being a busybody?
We don't agree. The bar is not a busybody. When it comes to constitutional issues, administration of justice issues, and certainly rule of law issues, and when there are concerns that the Constitution has not been complied with, or has been misunderstood or misinterpreted, then actually every Malaysian has an interest in it. None of us can be busybodies in a matter that is so important that goes back to the document which is our founding document. All right, and certainly the bar would have a say in it. The bar would be concerned about it because under our act, the Legal Profession Act, we are obliged to uphold the rule of law. That's a mandate that we have. Malaysian Bar is mandated to uphold the rule of law. Right. So by no stretch of imagination can you say we are a busybody. And let me explain this. This term busybody comes from a very old English case. If I'm not mistaken, it's called Boyce and Paddington. The law on whether or not a person, and I think you've heard this word called locus standi, that actually means whether or not you can bring an action. That law on locus standi has changed tremendously all over the world and even in Malaysia for persons to bring action. And our law today is actually a very progressive law that allows a person who is aggrieved by a particular decision to bring a case in court. So I think to say that there's no locus standi for the bar is looking at the law in a very outdated and regressive manner. All right, the law has been liberalized. Right?
In regards to the solicitors at the SRO, is the fee raise significant? Cost hike for the public?
No, there's no cost hike for the public. There's an increase in rates, all right? But that increase in rates is an increase that is the first increase that has been done over 10 years. The last time we increased the rates 10 years. And that increase is not confirmed because we are proposing an increase that has to go before a particular committee under the Legal Profession Act, chaired by the Chief Justice, Chief Justice, and Chief Justice has to approve those rates. So that's only a proposal. And on the other side, while the rates, there's a proposal to increase rates, we also took into account the public interests, and that's where we have the possibility now of lawyers giving discounts up to 25%. And then we are also, I didn't mention this just now, in the motion, we've also made provisions to carry on with what is known as our enforcement rules. So if there's any lawyer who breaches the solicitor's remuneration order, the fixed scale, then we have got certain rules that we have placed before the Attorney General's chambers, which will allow for enforcement action to be taken against those lawyers. So it's a balance. Yeah.
Given all these resolutions passed today, what is the bar's view, or based on what was discussed at the AGM, what is the bar's consensus or view about the state of justice and the judiciary and the legal system in Malaysia right now?
It's a very broad question. I don't think we are concerned about the judicial system. There's nothing about the judicial system today. Really, the concern today was about the public prosecutor, the Attorney General as the public prosecutor, and you must draw the distinction. The Attorney General is either Attorney General in his role as an advisor to the government, or the Attorney General as a public prosecutor. So the concerns expressed today was about him in his role as the public prosecutor. All right, that is still there. In fact, our suit is about that, in his role as a public prosecutor, whether or not he exercised his discretion in accordance to law, whether or not he actually took into account all the relevant factors, whether he ignored certain factors that he should have taken into account. And if he had not done so, our suit is for the purposes of the court looking at it, and the court then telling him that you need to look into these factors and decide in accordance to law. All right. So that's the sum and total of our suit. All right. And then you, of course, is the motion that we had. The motion of the Malaysian Bar today was to call upon him to resign because of all those underlying matters, which is essentially about the investigations into the alleged irregularities in 1MDB, in what is this, the transfer of funds into the Prime Minister's account, the 2.6 billion, as well as the 42 million. That was the concern that led to the motion, the concern that led to the decision he made, and therefore the motion, the decisions he made on the 26th of January 2016.
Few questions about CPD.
Yes.
Okay, it was just passed by one in favor.
It was passed by a majority vote.
But due to the very slim margin, why was the recount not done?
There is actually no provision for recount. That's the first thing. And second, what happened was as soon as the vote was taken, many members had left the room, and it was not possible. In fact, I actually had asked members to stay back because there were other motions, but they all had left the room. So there was no possible to reassemble and put the vote back on. So, so that could not be done. But, it is a one vote in the Malaysian Bar is still a vote of the Malaysian Bar. All right? And so that vote has been carried. But that doesn't mean, and I want to be very clear about this, that does not mean that the concerns expressed by the others who voted against the motion are not being taken into account. We have just had a council meeting, and we are looking into all their concerns to see how those concerns can be dealt with. All right? Because it's important. The Bar is united. The Bar is always united. We may have a debate, we may vote in particular ways, but after the vote is done, we come together, we move forward, and we take into account concerns that are expressed.
Speaking of members leaving, when it started, it was 1,100 members. By the third motion, we saw there was like only 200.
I can't tell you what the numbers were after the motion.
I'll focus on CBD then. This first round is going to affect about 6,000 members of 17,000 members.
6,000 members.
But the rest of the rollout is between now and 2024. How come it takes 8 years to affect the remaining 10,000 or so?
It is always done in stages. It is done in stages because members have a number of different concerns. One is affordability, the other is accessibility. So these two concerns have to be dealt with, which means we actually need to generate funds to give financial assistance in the programs that we run. So we have started initially with this group. That's the first group we start with. But we do not intend to stop with this group. We intend to move on after that to the next group. But because of the financial considerations and the resources that we have, accessibility issues, it has to be done in stages. But let me say this, the stages thing is really something that has not been decided today, in the sense that we are coming back in March 2018 to confirm the stages. In the meanwhile, as we run the program and we see how it works out, it is very possible that we may go back to the House even next year in 2017 and tell the House we don't need so much time. We can actually collapse the 8 years, you said just now, we can collapse the 8 years into a shorter time. But that all it depends on what happens in the next, you need to get the scheme running first, Kishan. If you don't get it running, you won't see how it works. So it's almost like a chicken and egg situation. Unless you start, you won't see how it finishes. So we are grateful today that we are able to start. All right? And I've asked members to place their belief in the council that we will roll this out in the stages and reach as many members as possible. And I hope to be able, the Bar hopes to reach as many members as possible in the shortest possible time.
about members for 30 years and above? There seems to be no provision for them.
There was a general exception on conditions for 30 years and above. That was it. But there were sentiments expressed today that even people 30 years and above should be able to participate. And we are not against that. We are not against that. In fact, we will encourage that. And the thing about when you say 30 and above is excluded, they are not excluded because it's the members 30 and above who contribute in terms of the lectures that are run. They run the lectures, so they are still part of the scheme. It's a one bar scheme, I must emphasize that. It's a one bar scheme that is going to take, which is going to be implemented in stages, rolled out in stages. It is not a scheme for one particular segment of the bar. It is for the whole bar. And we'll all work together, even if it starts with a particular group initially, the others will be contributing in that group by way of participating in the trainings.
Stephen, can I just ask, coming back to the motion of the Attorney General, the Bar's had a good relationship with previous Attorney Generals who've been consulted on drafts of bills and so on and so forth. Does this motion, represent a challenge in that it appears now there's a very adversarial relationship, something that was not, something that was not desired perhaps, but that's what it is now, isn't it? How do you see the working relationship going forward with the AGC?
It will be challenging. I think we must admit it's going to be challenging. But we hope that common sense will prevail. There are a lot of common areas of mutual benefit that we work on, and we look forward to working with the AGC in all these areas. We are certainly not going to be shutting our doors to the Attorney General's chambers, and we are hoping that they would not do that either, in the interest of the profession.
You mentioned that the motion on the AG was passed with a majority, but was it an overwhelming majority?
I'll just say it's a majority, right? Because I'll be very frank with you, we do not disclose the numbers in the vote because it's a private meeting, all right? So you can have it as a majority.
No doubt after this, we will be getting the usual comments about the Bar Council, the neutrality of the Bar Council, and there have already been certain groups of lawyers saying they want to set up their own separate thing. What is your response to this? Do you maintain that, in terms of these criticisms of the neutrality of the Bar Council, what is your response to that?
The Bar Council is neutral. We are pro-justice, pro-rule of law. We are blind to personalities. We look at the issue and we react to the issue. So the Malaysian Bar today, in passing the resolution it did on the Attorney General, was reacting to an issue. It concerned the Attorney General. It has nothing to do with the personality of the person.
The motion regarding the NSC bill says authorize Bar to undertake all appropriate action. What do you intend to do?
Well, we have been lobbying. It's not just us, it's also our counterparts in Sabah and Sarawak. We have indeed even written a joint open letter to the Prime Minister asking him to reconsider his position, reconsider the government's position on the National Security Council bill. We have pointed out the different areas of concern. We will carry on with the public awareness campaign where we can to inform members of the public. We've already had a number of them, but we'll carry on with that, informing members of the public as to the concerns, serious concerns that we have about the bill. And we know from press reports that the rulers have also expressed their concern about the bill. So we're not alone on this, all right? So we are hoping that government will engage us, and we are quite prepared to engage government to show and to explain the concerns that we have, the shortcomings in the bill.
Moving forward, will we expect to see more legal challenges mounted against the government?
We don't set out to mount legal challenges against anybody, whether the government, as and when an issue presents itself and it requires a response, then one looks at what is the appropriate response. So, for example, if you look at the decisions of the Attorney General on 26th of January 2016 on this whole issue, we sat and thought hard, deliberated about what is the appropriate response. The appropriate response here was to really file an action to have the powers clarified, to be very clear what the powers are, whether or not there has been an exercise of powers in a way that exceeds the jurisdiction of the Attorney General. So in our view, that's an appropriate and responsible way of handling the matter, because we have taken the whole thing into court. So we will be placing our best arguments before the court, and we have no doubt the Attorney General will be placing his best arguments before the court, and it's for the court to decide, one way or another, whether or not the powers of the Attorney General can be exercised in the way it was exercised.
Yeah, sorry. On your motion, there's a motion that says the bar is calling for an independent committee on the selection and recommendation.
Independent commission.
Yeah, to the Yang Dipertuan Agong for the Attorney General. Is this something that requires a constitutional amendment?
No, it doesn't. It is like somewhat like the Judicial Appointments Commission. You have a Judicial Appointments Commission that appoints judges, although the position of the judges is recognized in the Constitution. So you can actually have a layer just below the Constitution where this can work. So that's what we are looking at. So there'll be an appointment, a recommendation really, because the Agong is the appointing authority under the Constitution, and we recognize that. So there must be a procedure whereby the appointment entire process can be in a transparent manner. The recommendation given to the Agong should be a result of that process.
But will not like supersede the Prime Minister or anything like that?
No, it all depends how the commission is formed. All right, but you know the commission should be a commission that is independent of the executive. Because you see, we have always taken the position, the bar has always taken the position that the position of the Attorney General must be separated from the position of the public prosecutor. The Attorney General is under Article 145 sub 2. He is the advisor to the government. That's fine. So that can be a political appointment. But the appointment under 1453 for the Attorney General as public prosecutor should not be a person that is a political appointee. He should be a person who is rank and file, professional public prosecutor, who answers to public interests. And that's the approach taken in many countries, certainly in the UK, with respect to the Crown Prosecution Service and the public prosecutor there. Yeah. So that's what we have been looking at. Yeah. So we hope a process like this will lead to that separation, which is good, which is a very transparent way in which prosecutions can be handled without there being any allegations as regards the prosecutions.